Chapter 4, Parliament, Statutes and Secondary Legislation. 4.1, Introduction. So far we've looked at the fact that New Zealand is a common law country. That means its laws come from both statutes and cases. We've looked at how case law works. Now let's look at New Zealand's government and statutes. 4.2, New Zealand's 3 branches of government. New Zealand's government is made up of 3 different groups or branches. These branches are the legislature, the executive, and the judiciary. Let me explain them all now. The legislature make the law and hold the government accountable. Think of the word legislation, because the legislature make the legislation. It's made up of all the people in Parliament and the Governor General, who is someone who represents the King in New Zealand. The executive is the group of people who were the elected officials at the time. It's also referred to as the government. At the moment, the government or the executive in New Zealand is a combination of a few different political parties called the National Party, New Zealand First and ACT. The executive proposes laws. So they say to Parliament, hey, check out this law, you should pass it, it's going to be a great law. The executive is also responsible for administering the law. The third group of government is called the judiciary. This is the easiest one for us to understand because this group of government is made up of all of the judges in New Zealand. They're responsible for interpreting and applying the law, as well as sometimes creating new laws. 4.3, Separation of powers. In an ideal world, all of these branches of government should be separate. This is to enable each branch to hold the other 2 accountable. It therefore helps prevent corruption. For example, the legislature should make laws and the judges should interpret and apply them without being influenced or biased by Parliament. However, in New Zealand, the 3 branches of government are not perfectly separate. For example, the executive is also part of the legislature, as the executive forms part of Parliament. Also, the Chief Justice, or the top judge of the Supreme Court, is elected by the Prime Minister, who is part of both the executive and the legislature. 4.4, How Parliament makes laws. The entire process for how Parliament makes statutes is well explained on Parliament's website. In a nutshell, the executive puts forward an idea of what a law should be. This proposed law is called a bill. As a side note, other members of Parliament might be able to propose a bill, but they have to win their bill being put before the Parliament in a lottery system. A bill goes through lots of stages before it becomes a law. The bill is first introduced to Parliament. It then has what is called its first reading, where it's explained to Parliament. Parliament then votes on whether the bill should keep being looked at. If the bill gets a 51% or more vote for it to keep going, it then usually goes before a select committee. A select committee is a group of members of Parliament who look closely at the bill and get feedback on it from the public. The bill then goes to a second reading, then a committee of the whole House, then a third reading. Finally, if the bill is voted and approved and passes through Parliament on all of those stages, it is given what is called Royal Assent. Since the number 1 person in New Zealand, or the head of state, is still the King of England, or what we call in New Zealand, the King of New Zealand, the Governor General, representing the King, will sign off on the law and make it official. Once it becomes a law, it's called an Act of Parliament or a statute. All of the statutes in New Zealand can be found on the New Zealand legislation website. By the way, this is why a political party in New Zealand will want to have a majority in Parliament. If a particular political party has a 51% majority in Parliament, they can vote together and say yes to lots of new laws that they propose. This will give that party a lot of control over the laws in a country. 4.5, Secondary legislation. Sometimes laws are created in Parliament that give other government workers the ability to create some specific laws. These laws are called pieces of secondary legislation or regulations, or sometimes even rules. For example, a statute might say that a local council is allowed to make laws about how much it can charge its community for plastic rubbish bags. 4.6, Summary. We have covered a lot in this chapter. Let me give you a quick recap of everything that we've learned. New Zealand's government is made up of 3 different branches. The legislature, who make the law. The executive, which is the government that is elected at the time. They administer the law and propose new laws. And the judiciary, or the judges. They make new laws and interpret how statutes should be applied. These three branches of government should ideally be separate. That way, each group can hold the other groups accountable. This makes the country less corrupt. However, they're not perfectly separate in New Zealand. Parliament makes laws through quite a long process. Generally, the executive presents a bill to Parliament. Parliament then votes on whether the bill should become a statute multiple times. Statutes can sometimes give other government actors the power to make laws. The rules made by people who are not in Parliament are called regulations, rules, or secondary legislation. In the next chapter, we'll look at how the judiciary holds the executive accountable and what government actor is at the top of the hierarchy.